Hi friends, good morning, good afternoon, good evening. ಹೇಗಿದ್ದೀರಾ? ಆಯ್ತಾ ನಾಷ್ಟಾ ಊಟ ಎಲ್ಲ? Yes, I'm good. Thank you. I'm your CA Veeraj. We will continue with our discussion on Companies Act 2013. So in the last class, we were discussing about the Companies Act 2013. What is company? What are the features of company? What is an act? How the act has to be read? How it has to be interpreted? All those things we were discussing in the last class. Now we will continue the same discussion on the Companies Act 2013. So our target for today is we will begin with the types of company. What do we start with today? We start with the types of companies. The types of companies. Sir, what are the types of companies? The types of companies. There are many types of company. Sir, what are those? You might have heard, sir, ours is a private company, ours is a public company, all those things. Here in Companies Act, they divided companies into many types. So without wasting any time, we will get into the concept. So the first type of company which we are discussing is based on the liability. Based on the liability, there are three types of company which are there in our Companies Act. Sir, what are those type of company which we already discussed? In case of that limited liability, remember the company which is there is company limited by shares. Again, company limited by guarantee. And the third type of company is unlimited company. Unlimited company. Unlimited company. Again, we already discussed it. I am not repeating this again. I'll just discuss in a line and we'll move forward. The company limited by shares means when I say liability, we are discussing about the liability of the members towards the company, not the liability of the company towards the outsiders. You should keep this in mind always. Is it okay? Done. When I say company limited by shares, the liability of the members of the company is to the extent of unpaid up value of shares. This is what we discussed. Whatever the value of unpaid up value of the shares is there, that is what our liability. The first, for example, the first example is company has issued some 10 rupees worth of share on which I paid 5 rupees. The remaining 5 rupees is my liability. The moment I pay that 5 rupees, the liability gets exhausted. That is what the liability. Company limited by shares. Then comes company limited by guarantee. The company limited by guarantee is a company in which the members are not purchase the shares, but they are agreed to give, contribute some amount of money at the time of winding up of the company. Again, the unlimited company also says, the name itself says the member of the liability of the members is totally unlimited with respect to the company. This limited by guarantee can be with share capital. Second one is without share capital also. Can it be there? Yes, it is possible. This unlimited also with share capital, and unlimited can also be without share capital. So if you have not watched the first video, which is around some 40 minutes, please go through it. That is very, very important. That is like the foundation stone. You have to watch it. I strongly recommend that. Don't worry about the 40 minutes. And explanation for these things is also given in that 40 minutes video in a crystal clear manner. Is it okay? We will continue. This is the first type of the company which we have discussed. This is second one, and this is the third one. Now we will continue with fourth type of company. We will continue with fourth type of company. Sir, what is this fourth type of company? We will begin with public company. We will begin with public company. Sir, what is public company? You tell me. The Companies Act defines the definitions in multiple ways. One, I categorize the definitions into mainly two categories. I generally do it for 3, but as of now we will keep it as 2. One type of definition which I categorize definition under, That is very conceptual, very in-depth definition. The moment you see the definition, you don't need to see here and there. Sir, I'm feeling some doubt regarding no, you don't get even a single doubt also. The moment you see those type of definitions. We will discuss those type of definitions also. For example, the private company definition, which we are going to discuss immediately after this public company. Then the next type of definitions are like you feel, sir, is it a definition or just like they're in, I don't want to tell it, just give it. Instead, for the sake of giving, they just giving it. Sir, how is it? The public company definition is one of the example for that. For example, what is public company? Public company is a company which is, it is a company which is other than private company. Even if for the purpose of telling also I am getting the offer. Which is other than private company. Again, they have one more thing, which has a paid up capital. I call it as PUC, paid up capital, as prescribed. Which is a paid up capital as prescribed. Sir, how much is prescribed? Nothing is prescribed. Don't worry regarding that. So, a company which is other than the private company is called as public company. Is it okay for you? Sir, if it comes in the examination, do we need to write the same thing? Yes, you have to write only two things. This point and the second point. Is it okay? So, we will continue with the next definition. The next definition is very conceptual. This is one of my favorite definition also. The definition of private company. I think we will take it in the fresh page only. That is very important. The definition of private company. Sir, what is this private company? How do you define it as a private company? Sir, can we tell it like other than public company is a private company? No. No. It can't be the two way. The moment you say public is other than private, you have to define it. Then only they come to know that, the people will come to know that what is the private, what is the public. So, for the purpose of defining the private company, I want to introduce two words, I think which you already know because it is a revision video. The two words are MOA and AOA. MOA is a Memorandum of Association. AOA is the Articles of Association. Sir, what is this? As our country has the Constitution of India, that is a supreme document which gives the power, rights, duties, obligations, everything with respect to a country, citizen, politicians, everybody in a country. But the same way, the MOA and AOA are also the supreme documents which a company has to maintain by itself. A company, it defines, MOA and AOA defines what a company can do and what a company cannot do. What are the rights, what are the liabilities? All those things are given under this MOA as well as AOA. Okay, sir, we understood what is MOA, AOA. Don't worry if you don't understood also. We are going to discuss this again in the further concepts. Section 4, 5, 6, all those things are there. Now, sir, why did you tell it now? Because one point is related to this part, private company definition, where it says, listen to the definition very carefully. I think we might spend some 7-8 minutes on the same definition itself. Listen to the definition. Private company means a company in which by which in its articles, or articles means AOA, in which its articles, it has three conditions. In its articles, it has three conditions. First one is restricts the transferability of shares. I'll first list out the conditions, then we will go to in detailed discussion. One is restrict the transferability of shares. Then prohibit the invitation to the public for subscribing its shares. What is the second condition? which will prohibit the invitation to the public for the purpose of subscription to its shares. And the third condition, see the conditions are rearranged for the purpose of better presentation and better understanding. I have rearranged it. The third one is, except in case of OPC, except in case of OPC, the number of members are limited to 200. I think you might have by-hearted everything. No need to by-heart. I think so many people, 50% of the people did not understood this definition. So don't worry, the moment we complete this one, it will be a crystal clear idea in your mind. 200, except in case of OPC, the number of members are limited to 200. But however, for the counting of 200 members, the following are excluded. The following are excluded. Sir, what are those excluded? The first one is the first exclusion here is employee shareholders. Are excluded. The second exclusion is ex-employees, shareholders. Don't think about your ex. It is a study time, not to think about those things. Ex-employees. And third exclusion is joint shareholders are considered as a single shareholder. Joint shareholders are considered as single shareholder. Sir, do we need to write the entire definition when they ask the private company definition? Yes, sir. This is the complete definition which we have to write it in the examination. Don't worry, it is 3 simple points definition. Wherever it is important, I'm trying to highlight it, try to catch up the things. So private company means a company in which by its articles, that means it has to be mentioned in the articles. Sir, we are restricting the shares, prohibition, everything is there, but articles of association not mentioned those conditions. No, it doesn't work out like that. You have to mention these 3 conditions in the AOA, articles of association. What are those 3 conditions? First one is restrict the transferability of shares. What is that restrict the transferability of shares? As you already know, how many number of members are required for the purpose of private company? There are minimum 2, maximum 200. 2 and 200. Consider 5 people combined together has formed one private company. Generally, this private company, the word itself says it is between some small group of the people, like the husband, wife, father, mother, son, daughter, all those people. Now, what is that restriction? Can a member means the owner means the shareholder. Shareholders are called as members of the company here. Can the members transfer the shares? Yes, they can transfer the shares. I'm not telling they can't transfer the shares. Consider A, B, C are there. A, B and C. Now, A want to transfer the shares to the D person. A want to transfer the shares to D. But because whenever A want to transfer the shares, he has to take the permission from B and C. If they agree, then only he can transfer the shares. I'm not telling prohibition and transfer. The transfer is restricted. How it is restricted? You should get the permission of the remaining members of the company. That is the first point. Is it okay? Understood? Yes, sir. We understood that. The second point is prohibit the invitation to the public for the purpose of subscribing the shares. It is like, you might have heard that company going for IPO, company going for FPO, all those things. Initial public offer, further public offer. This type of private companies cannot go for IPO and FPO. Sir, what is that IPO and FPO? Issue of shares to the public is called as IPO and FPO. The shares cannot be issued to the public in general. Sir, then how can somebody become the member? There is a concept called as private placement. There's a concept called as what? Private placement. By way of that, by giving the private placement, all those things, they can become the members of the company. One is restrictions on the transferability of shares. I will not leave until you remember this definition. Restriction on the transferability of shares. Prohibition on the invitation to the public for the purpose of subscription. If you look at the language, very, very beautifully drafted here. One is restriction. Second one is prohibition. Restriction and prohibition. The third one is except in case of OPC. Why except in case of OPC? We'll learn it in OPC related definition. But as of now, you remember, except in case of OPC means OPC one bitto. All the other private companies members are limited to 200. I'm not telling private company should have only 200 shares. I'm trying to tell that private company should have maximum 200 number of members, not more than 200. Is it okay? Sir, what do you mean by not more than 200? Sir, I'm holding 1 lakh shares. That's okay. You are a single member. Sir, I'm holding only 1 share. Still, you are a single member. It is categorized not based on the number of shares. It is based on the number of members who are there with the company. Except in case of OPC, because OPC consists of only 1 member. Minimum is 1, maximum is 1. Except in case of OPC, the number of members are limited to 200. But for the purpose of counting the 200, we will exclude the following members. Sir, who are the following members? Employee shareholders are excluded. Sir, what is this employee shareholder? You heard about the concept called as ESOP, certificate shares, all those things. Whenever the company is, pleased with the service given by the employees, or whenever company want to retain the employees, whenever the company gets some know-how, patent, trademark from the employees, it will allot some shares. Now the employees are getting shares not because they are giving the money, because they are giving their services. That is why we are excluding that. The shares are allotted in the capacity of employees, but not in the capacity of shareholder. Understood the concept? Understanding this thing? Very important definition. Because they are getting the shares in the capacity of employee, they are not considered as a member of the company. Because still I am in the employment, I am holding the share. No, you are not an employee. Sir, they allotted the shares for me when I was in the employment, but now I am not in the employment. Then also you are not considered as a member of the company, because those shares you received because of the employment of the company, not because of the member of the company. Employees as well as ex-employees. Sir, but I got one doubt. I know you might have got this doubt. I am an ex-employee, sir, now. When I was in employment, company allotted me 100 shares. In 2005, for example, we'll take the dates. In 2005, company allotted me some 100 shares. In 2020, I sold that 100 shares and I left the company. Sorry, I left the company in 2020. I sold those 100 shares after 2020. Consider 2022. Shares allotted 2005. I left the company 2020. I sold the shares 2022. Okay. After selling these shares, I bought few more shares in 2025. Because I am holding those shares in 2025 purchased, will I be called as member? Yes, you will be called as a member, because when you bought those shares, you are not in the employment of the company. Those shares are not allotted because you are in the employment of the company. You paid the money and you got those shares. That is why those things are included. As of now, when you are in the employment, the shares are allotted, but you left the company, but you are still holding the shares. Doesn't matter, you are not a member of the company. Except in case of OPC, the number of members are limited to 200. But for the purpose of 200, employees, ex-employees are excluded or shareholders. Then joint shareholders will be considered as a single shareholder. What is this joint shareholder? I think when you are the minor school, you will be opening an account, joint account in the bank with your parent, either mother or father, like that. Till the account is single only, but it is held in the two people name. The same way here also, joint shareholders are considered as a single shareholder. One account, one member. Is it okay? There is one important question on that will generally come for 5 to 6 marks in the examination. We will try to cover that question at a later point of time. Is it okay? Okay. This is one more definition of company. One is private company. Then comes The government company. What is this government company? The company which is held by government. Company which is held by government. Before, sir, what is that? Can you explain in detail? Yes. Consider it is a company in which the government, I call it as government group. Don't write this language for simply explaining that I am using the government group. But what is the main definition I am writing here? In which the company, the government, in which either the central government or state government or state governments or central government plus state government or governments are holding not less than 51% of the share capital. You try to analyze this definition, very important. I am using the word not less than 51%. Sir, if they are holding 51%, is it called as government company? You think, what could be the answer? Exactly 51%. Is it government or non-government? Sir, is 51 less than 51? No, sir. 51 is equal to 51. At least means at least 51 should be there. That means is equal to 51. 51 is not less than 51. 50.9999 is less than 51. Done? I'm just joking. Exactly 51 is also considered as a government company. And it includes, the definition is not over yet, it includes the subsidiary company. It includes the subsidiary company of the government company also. What is government company? It is a company in which not less than 51% is held by either central government, state government, or state governments, or central plus state, or central plus multiple states, and in which it includes the subsidiary of state government also. Is it okay? That is called as government company. Sir, can you give an example? Yes, we can discuss that by way of example. Consider there is Karnataka government. Our Honorable Chief Minister Sidramaya, or Sidramaya, actually the share capital is held by governor only. The Karnataka government in A Limited is holding 40%. Karnataka government in A Limited is holding 40%, and Maharashtra government is holding another 40%, and others are holding 20%. Maybe like people, you and me, individuals are holding 20% in A Limited. Now, will the A Limited be called as government company or not? For that, we have to discuss the again definition. Not less than 51% held by state government, central government group. Here, Karnataka government plus Maharashtra government combinedly, how much they are holding? 80%, sir. Is it less than 51%? No, sir. It is more than 51. Then this A Limited will be called as the government company. A Limited will be called as government company. Now this government company also includes, there is B Limited, in which more than 50% of the control or voting power or control the board of directors is there with A Limited. Sir, what is this thing? Don't worry, we will discuss in a minute. First, you understand. More than 50% is held by A Limited. Because A Limited is holding more than 50%. That means consider 50.1% in B Limited. And A Limited is a government company. Now B Limited also will be called as the government company. Anyhow, what is the definition of government company? Government groups should hold more than or equal to 51% in your company. But government is already holding more than 51% in your company, more than or equal to. Along with that, you are holding more than 50% in other company. Even though less than 51 but more than 50, still you will be called as the government company. A Limited as well as government B Limited is also a government company. Is it okay? That is how the definition has been dissected. The next definition is the holding company. The next definition is the holding company. Sir, what is holding company? It is again a simpler definition. It is a company which holds one or more subsidiaries. That's it. Which is called as holding company. Very simpler definition like public company. But again comes the 8th definition and important definition. The subsidiary company. Subsidiary company. What is subsidiary company? Again, interesting as well as bit lengthier definition to try to understand. It is a company. It is trickier till we discuss it. The moment we discuss, it becomes very easy. Don't worry. It is a company in which the other company, that is holding company. Other company is a holding company. Other company holds not less than 50% of the voting power is not less than holds holding company holds voting power of 50% or not 50% or more than 50% or which controls the composition of board of directors. Very interesting definition. It is a company in which the other company is holding voting power of more than 50% or which controls the composition of board of directors. Sir, what is this holding more than 50% of these things? Generally, earlier, the voting power word was read as share capital. Earlier, there was something called as share capital. Now it is read as voting power. What is voting power? Generally, when I say voting power, there are two kinds of voting power. One is, I'll discuss it later, UVR. Second one is DVR, uniform voting rights and differential voting rights. What is uniform voting rights? Every share gets the equal vote. As the other share is also getting, I am also getting the same vote. That is uniform voting rights. Here, you should have either UVR or DVR. At least more than 50% of the share capital of the company. That is voting power of the company. No, sir, I am not holding 50% or more than 50% of the voting power. Then you should at least try to control The composition of board of directors. You should try to what? Control the composition of board of directors. Sir, what is control the composition of board of directors? What is the word of this composition? Composition is like, consider board of directors, it should be composed of this thing, this person, this person, this person. What it should consist of? In case of board of directors of a company, other company, subsidiary company, consider, we will take an example. There is A Limited, there is B Limited also. If A Limited can control the composition of board of directors in B Limited, then A Limited is called as holding company, this is called as subsidiary company. Sir, what is this composition? I'll explain now. Consider, as per the Companies Act, there are some minimum requirement of the directors. Consider public company, minimum 3 directors are required. Up to 15 directors they can appoint. More than 15 directors, they have to again pass a special resolution and appoint the director. Consider, they are appointing, consider some 5 directors are there in B Limited. Out of the 5 directors, if at least 3 directors are appointed by A Limited, 3 directors are appointed by A or removed by A, both the things. Either it should be appointed by A Limited or it should be appointed by removed by A Limited. Both the things we call it as appointment and removal as composition. What is this controls? Control means more than 50%. Control means more than 50%. That means more than 50% of the director. 3 out of 5 directors. Yes, sir, it is more than 50% only. That is 60% of the directors are appointed by A or removed by A. Because of which A Limited is called as holding company, B Limited is called as subsidiary company. A Limited is called as holding company, B Limited is called as subsidiary company. Is it okay? Holding, subsidiary? Okay, sir, we understood holding and subsidiary company. The next type of company which we are going to discuss here is, associate company. Associate company. What is this associate company? Associate company is like, it is a company in which other company, here other company does not mean holding company, it is, we call it as investor company. Investor company. Investor company has, it is a company in which other company can exercise the significant influence on this company. Exercise significant influence is called as the associate company. Sir, what is this significant influence? Here the word significant influence is also defined. Significant influence is nothing but holding at least 20% of the voting power. What is this? At least 20% of the voting power. What is this at least 20% of the voting power? So, sir, I am holding 20% of 15% of the voting power. Am I associate and investor company? No, sir. We are not associate and investor company. Sir, I am holding 19%. Am I associate and investor? No, sir. Sir, I am holding 21. Yes, you are associate and investor relationship. Sir, I am holding 45. Yes, still you are associate. I am holding 49. Still you are associate. Sir, I am holding 51%. No. Don't forget that. We just discussed that holding and subsidiary company, in which the other company has control of more than 50% of the voting power. If the moment it crosses 50, it becomes holding and subsidiary. It is up to 50, not exactly 50, up to 50 and more than 20 is called as associate and investor company. The company in which holds, the company which invested in the company is called as investor company. The company in which the company has invested, this company is called as associate company. Associate to this investor company. Up to 20%, no relationship at all. It is just the shareholding. 20 to 50%, 50% associate company, more than 50%, then it is subsidiary and holding company. Sir, then it is exactly 50. Oh, then it is joint venture company. What is that? Joint venture company. This is the 9th definition. There are some other definitions also. We will discuss those definitions in the next video. If you have liked this video, please like it, subscribe it, share it, and don't forget to press the bell icon. Thank you. Bye bye. It's your Veeraj. Thank you.